PhD scholar from School of Biomedical Engineering, Varanasi, and I will be your anchor for today's one-day IPR awareness workshop organized by IDBHU and sponsored by CST-UP, Government of Uttar Pradesh and IDAP Hub. This workshop is dedicated to creating awareness about intellectual property rights among students, researchers and faculty. In today's research ecosystem, publishing is not enough. Protecting our innovation is equally important. Intellectual property rights safeguards the originality of our work, give legal recognitions and rewards to creators, and enable university to translate research into technology and startups that benefit society. That is why workshops like this are crucial for all of us in academia. Now welcoming of dignitaries. Now on behalf of IIT BHU, Varanasi, I extend a warm welcome to all our dignitaries on the dais. First, I would like to invite Professor Nilay Krishna Mukhopadhyay, Dean of Faculty Affairs and Professor in the Department of Metallurgical Engineering, to kindly take his place on the dais. Next, I invite Professor Rajesh Kumar, Dean of Research and Professor in the Department of Civil Engineering, to kindly join us on the dais. I now invite Professor Ram Sharan Singh, Project Director of the IDAP Center and Professor in the Department of Chemical Engineering, to kindly take his seat on the dais. Next, I would like to invite Professor Pradeep Paik, Associate Dean of Research and Development and Coordinator of the IPR Cell, IIT BHU Varanasi, and the Professor in the School of Biomedical Engineering, to kindly take his seat. Now, last but not the least, I would like to call Professor Abha Ma'am, Dean of Research and Development, to kindly take his place on the dais. I once again welcome all our dignitaries on the dais and all the participants present here. Now I request all our esteemed guests to kindly come forward for guarding the bust of Mahamana Pandit, Madan Mohan Malviya ji, and lighting the lamp. शुभम करोति कल्याणम आरोग्यम सुख संपदम शत्रु बुद्धि विनाशयाम दीप ज्योति नमस्तुते. Momita Roy from School of Biomedical Engineering to kindly come forward and lead us in the Kulgeet. I request everyone in the audience to please do not clap after Kulgeet concludes.
मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी राजधानी मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी राजधानी ये तीनों लोकों से न्यारी काशी सुज्ञान धर्म और सत्य बसी है गंगा के राम तट पर ये सर्व विद्या की राजधानी राजधानी मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी राजधानी नए नहीं है ये ईंट पाथर है विश्वकर्मा का कार्य सुंदर रचे है विद्या के भव्य मंदिर ये सर्व सृष्टि की राजधानी राजधानी यहाँ की है ये पवित्र शिक्षा कि सत्य पहले फिर आत्मरक्षा बिके हरिश्चंद्र थे यहीं पर ये सत्य शिक्षा की राजधानी राजधानी मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी राजधानी वेद ईश्वर की सत्यवाणी बने जिन्हें पढ़ के ब्रह्म ज्ञानी थे व्यास जी ने रचे यहीं पर ये ब्रह्म विद्या की राजधानी राजधानी वो मुक्ति पद को दिलाने वाले सुधर्म पथ पर चलाने वाले यही फले फूले बुद्ध शंकर ये राज ऋषियों की राजधानी राजधानी मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी राजधानी सुरम्य धाराएं वरुणा से नहाए जिनमें कबीर तुलसी भरा हो कविता का क्यों
Professor Pradeep Pai to testimonial all the dignitaries present on the dais. Shivani. Now I request Professor Pradeep Paik, Associate Dean R&D and Coordinator IPR Cell IIT BHU Varanasi to deliver the welcome address and briefly introduce the initiative of IPR Cell.
Good morning, everyone. On behalf of the IPR Cell and Dean R&D Office of IIT BHU, I am delighted to welcome you to the second year IPR Awareness Workshop 2026. It is my honor to welcome you, Dean R&D, Dean Faculty Affairs, Director of the IDEP, and Associate Dean R&D, and along with all other students gathering here. Our chief guest was Professor Virinchi Kumar Sharma from IPR cells of BHU. Due to some other engagement, he is not able to come today. Due to the heavy load, Director Sir's health is not permitting to attend this program, but his presence is and the blessing is always there with us. Along with this, I welcome all the other students, faculty members, scientists, staffs, speakers, Dr. Sita Sharma and Dr. Gitika from Khurana and Khurana. Over the next few hours, we have exciting lineup of sessions designed with various dialogues and talk over the activations of the IPR. I hope you will take full advantages of the workshop and networking sessions to the friends, colleagues and others. We hope to leave here with new perspectives on how to file patents and other related things up to the technology transfer. Before we begin, I would like to express gratitude to our sponsors, UP Dean R&D, and the project director of the IDEP cells, to sponsor us and to organize these programs. Thank you all for being with us. Let's make this event successful so that we can take home message to organize our IIT BHU with a meaningful IPR and subsequently for the technology transfer. Thank you all, and once again I welcome you all.
Thank you so much, sir, for your insightful words and for outlining the vision and activities of IPR cell of IIT BHU. Now, I would request Professor Arun Mishra, Associate Dean of Research and Development, to say a few words about IPR.
Good morning to one and all my respected dignitaries who are sitting on the dais, and all the senior faculty members, Dr. Tapash Kumar Nandi ji. I feel privileged to welcome you all. So I have just now been given a task to tell you about the patent status. Before this, all I would just like to say is understanding, IPR is not just a legal necessities. It will give you a strategic tool, to protect your creativity. So I hope that this workshop will help you in, designing, how to know about the novelty of your work, how to find out the inventive steps in those work, how to write the claim and specifications. So I think all those deliberations will be given by the experts, will help you in designing your work in a different perspective. So far, if you have started working in that area, that's good. Otherwise, you definitely are going to enrich by these activities which we have designed for this IPR session. So let me just give you an idea about the data which has been given here. Is like in the patents in the year 25-26, all I would say that 5 patents number is around 206, out of which patents published is 142 and patents granted so far is 73. So it's a very good number for just 1 year. So I hope that with this workshop and the work which you have already initiated brings many more patents and breakthrough and technology transfer to IIT BHU. Thank you to all of you.
Thank you, ma'am, for your kind words. Now I request Professor Rajesh Kumar, Dean of Research and Development, IIT BHU, to share his thoughts with us.
Thank you. Good morning to everyone. Professor N.K. Mukhopadhyay, Dean Faculty Affairs. Professor R.S. Singh, Project Director, IDEP Hub and Head Department of Chemical Engineering and Technology. Professor Abha Misra, our colleague, Associate Dean of Dean R&D. Professor Pai, Associate Dean of R&D and Coordinator of IPR Cell. Professor Tapas Nandi, the Director DIA COE of IIT BHU. Others, my Deputy Registrar, Devinder, other colleagues sitting in the audience, our staff, dear students. So I feel privileged to be here among all of you and share the thoughts related to the IPR and the workshop which is going to be organized today. As Professor Abha Misra has told you, that this era is era of the creativity, startup, innovations, etc. In all these 3 things, you have to protect your idea and startups. Earlier, people used to write the idea through the paper publications or through development of some product. But it didn't go for the IPR and patenting of the project. And due to that, we have lost so many things. We could not recognize ourselves outside of the world and within the India. So I request to all the students, those who are working with the faculty members and doing some research, try to develop yourself to create something which is unique in nature and also it is related to your research topic. For example, suppose you are doing research in the drug industry, try to protect your idea, try to patent it so that your work cannot be available free of cost to all over the world. Later on, you can give to the world. What thing is that the name will be the name will be yours. So this workshop will give you the idea how to write and how to apply the patent, and our Dean R&D office through IPR cell, you are ready to help you in 24/7. As far as this workshop is concerned, this workshop we have designed and it is well in demand that faculty members and students are requesting to the Dean R&D office, please try to organize one workshop where we can know the details of IPR and the patent and etc. So once again, I would like to congratulate Professor Pai and his team and his staffs and all for organizing this workshop in very short span of time, and also those who are supporting this workshop to aware, to give idea about the patent and IPR. So thank you once again and welcome to all of you. Thank you.
Thank you so much, sir, for your encouraging words. Now, next, I would like to invite Professor Ram Sharan Singh, Project Director of IADAPT IIT BHU, to share his views.
So, very good morning to all of you. Mukhopadhyay sir, Dean of Faculty Affairs, Professor Rajesh Kumar, DORD, Professor Paik, and Professor Afa Misra, and I am seeing Dr. Nandi, he is from DRDO, Director, and then our Joint Registrar Devendra is here, he will help you in all this activity. And then we have Dr. Santanu Das from Ceramic Department, and I am heading IDEP, so our CEO is all there, Mr. Gopal. So on behalf of IDEP, I am here. So thank you for inviting me, Professor Pai. How many of you know about IDEP? Please raise your hand. So very few people know about IDEP. It's integral part of IIT BHU. It's a Section 8 company, so we have more flexibility in funding all sort of thing. But it's integral part of IIT BHU and it's Section 8 company. And we are funded by DST, Department of Science and Technology. What kind of activity we promote? Basically, we promote the research project, we fund them, and we can help them in many other ways. We promote the startup, that is very important nowadays. And in my view, as compared to other established IIT, like if you take the example of IIT Chennai, we are lacking behind. We are, the students have idea, they have good idea, but then they need the incubation of that idea. For that purpose, IDEPT is there, and IDEPT is basically for funding of DAPT area ideas, data analytics and predictive technologies. We also fund STCs, short-term training program of 5 days based on DAPT. So we are in this area, and our office is behind the director office. Any time you can come. How many UG students are there? Undergraduate, PG? Good number of the PhDs. We have good amount of fellowship for you. Fellowship, we have regular fellowship and top-up fellowship. Suppose any student is working in the area DAPT, his work is very good. His work is very quality, very good. We can give the top-up fellowship along with regular fellowship. So all kind of activities we promote, we give. So please visit the IDEP website. Please visit, and then you can come to me, you can contact. Even if you are like UG fellowship, we provide UG fellowship on any kind of project. You have some innovative project, you can come to us. On single project, we can give the fellowship to 3 students. Then in the fellowship, we provide UG people 4 to 5,000 per month. And any other grant they require to convert the idea into product, that we provide. So that kind of activity we do from IDEP. Now, because DAPT is our area, So how AI, DAPT is data analytics. You can say short word AI/ML. That is very popular. At all forum, two words you will listen nowadays. One is AI/ML, another is sustainability. Both words are very common. All forum will listen this word. So how DAPT can help the startups? So one area we start not startup patents. One area, two things are there: protecting copyright, protect patent, and second thing is the monetization of patent. Are you able to commercialize that patent? So AI, with help of AI, you can initially evaluate whether there is commercialization potential in your patent or not. That is possible. Copyright, which is important for us, which can give us money, which can give us value, that kind of. Otherwise, patent is just sleeping paper. Sleeping. So that is very important once you are going for patent. On AI/ML can help in this regard. Then avoid duplicacy. You can easily know by AI/ML tools if there is any duplicacy. Then strengthen claim quality. That you can know. And then support commercialization. AI/ML you can know how we can commercialize our patent. So these kind of AI/ML, this kind of things you can get from the AI/ML based apps or tools. IDAPT is ready. IDAPT is always, we talk to director sir also. So we are ready for monetization of IIT-BHU patent because we are Section 8 company. So we charge. We are company, not pure government body. So it's on the chargeable basis. Something. So I request Professor Pai to initiate. So we are ready for, because a lot of patents every year we are going for 200. But if you go for commercialization, product development, very less. So it's not that there is no potential in that patent or IPR. The problem is that we are not focusing, we are not commercializing, we are not you can say publicizing. So that kind of thing are required. So we can help the IIT-BHU, IDAPT can help for monetization of product, patents or IPR, and we can also help the sale of the patent, partial selling of the right to any start. So we can connect the startup ecosystem with IIT-BHU. We are in very important position because our theme is based on DAPT, data analytics. It is the initiative of DST, Department of Science and Technology. So all students, if you have any idea, if you have anything like related with startup idea, you can come to us. And I also request, but Professor Pai is doing very good. 2-3 folds increase in number of patents. So this is the path. First, if you increase the number, then you start for commercialization. So this is normal path. So thanks once again, Professor Pai, for inviting me. Thanks to all of you.
Thank you so much, sir, for creating awareness about the IPR and encouraging and motivating us to fight for the intellectual property rights. Now I would like to invite Professor Nilay Krishna Mukhopadhyay, Dean of Faculty Affairs and Professor in the Department of Metallurgical Engineering, to kindly take his place twice.
Good morning, Professor Rajesh Kumar, Dean R&D, Professor R.S. Singh, Head of the Department of Chemical Engineering and Director of IDPAT, Professor Pradeep Paik, who is the organizer of this particular workshop, and Professor Abha Mishra, Associate Dean, Dean R&D. And I see my colleagues, I wish many more of my colleagues could have been present today. I at least see Professor Shantanu Das and my good old friend Dr. Tapas Nandi, Santosh Rao and Ashish Mishra, and my staff, colleagues and students, ladies and gentlemen. And of course I must mention Dr. Shweta Sharma and Gitika, well, most welcome. First of all, let me express my gratitude to Professor Pradeep Paik, who is always insistent, though I am not directly part of this IPR, but because of him and because of the ecosystem developed in the institute, I also slowly developed my interest towards the IPR, patent, and many other things. See, as Professor Abhay Mishra mentioned, that it's a kind of not only the legal tool, but also it's very important to understand the philosophy of IPR. Why IPR is required? See, I started my research in 1983 in IC Bangalore. Just last 5 years, in the last 5 years also, I was not so much interested in IPR. And my pleasure was to publish a good public paper, to attend a very good conference, international conference, and that's all. But now the time has changed. It's what you work. You must inform the world. That's important. But then if there is some component of technological development or commercialization possibility, then first thing is to protect it. And IPR gives that way forward to protect your innovation, your invention, creativity, and originality. So therefore the ecosystem in all the IITs and other institutions have started developing, and now while doing your research you must understand whether this is original, new, or really innovative work or not. If you can understand that, yes, so to do that you have to also understand what is going on and what is the state of the art in this kind of research field. Once you are convinced that something new you have done, then there is always a possibility, and our IPR cell is quite active to help you. And because government also has given kind of importance because of the Make in India effort and self-reliant Viksit Bharat, so government also wants that India should be independent as early as possible, if not by 2047, 100 years after independence. So all sorts of, so what IDPAT and IPR cell of course is controlled by the Ministry of Commerce, and IDPAT, Department of Science and Technology, which reflects the government's intention and to emphasize that work what you do, try to develop some technology, try to protect through IPR, patent, and of course the end is the technological transfer so that industry can utilize it. If the industry cannot utilize, then my colleague mentioned patent is like a sleeping file, you said, sleeping paper. It's like a sleeping paper, it will like a sleep and it will gather dust and then it will be thrown out of the basket. So that's why it is important that how could that work for the commercialization. And why commercialization we are trying to do it? Because the research what we are doing and government is investing everywhere. This concept was earlier available in the industry. ROI, return on investment. Whatever you are investing, if it is not coming back anything, then industry will not be interested. So the government also wants that educationists, researchers, they also should be aware. They should also be encouraged to think in terms of the ROI. So that means you do research, you do as far as your own interest is concerned in terms of the fundamental and basics. That of course is required, otherwise all technology will just be a standstill. But at the same time, you also should look for whether there is a possibility of commercialization or not. proper technology development or not. And that's why the return on investment will be justified. If the return on investment, if it is not justified, then we will fail for the sustainability in terms of our research, engineering research, scientific research, and even to some extent our education also will get affected. Because everywhere the society needs some development in terms of the economic development at the end of the day. I met two of our students who just completed their undergraduate from electronics department just 5 to 6 years back. And Ministry of Commerce, they organized a meeting, the IPR and all these issues of commercialization, copyright, and GI tag, geographical indication tag, and all this intellectual part of intellectual property right. And that student, while doing a project here, 2 or 3 of their colleagues, their friends, they thought of developing something new in terms of the startup. I must tell you, the startup concept is also very new. Earlier times we never knew what is startup. Last 10 years and all, the startup concept has come. So I had to ask somebody, what is startup? He said, it's a company, but it's not well-established company, small company, trying to explore something. It may succeed, it may fail. So I said, what is the difference between company and then startup? He said, the difference is the government is encouraging, government will not put enough tax, government will also support in terms of the monetary subsidy and all. But if you fail, it doesn't mean that you will fail. One distinguished alumni who was visiting here, he said that I tried through 2-3 startups and I failed. But then I got some idea. Then when I started the next startup, that made him millionaire. So he says that startup has the risk and startup has also the gain. So no risk, no gain. So when I asked some alumni from our electronics department during the meeting in the Ministry of Commerce, he said that they have developed a nanotechnology, some nano devices, and that can really effectively utilize in the energy storage, energy transmission and all. And L&T has given a very big offer to get that particular kind of startup if they want to transfer to them. And with that offer that I also will be absorbed in their company. I said, why don't you start on your own? He said, sir, you require lots of money. And in front of this big giant, you cannot do that. You can do startup only. But later on, maybe in future, I can think of a big company, but I cannot compete with the L&T. And when L&T has given an offer, this is a very huge offer which I cannot think. So L&T has taken up. Now the question comes that why L&T has taken interest and taken up that particular technology? Because L&T may not invest money for R&D to explore. But if somebody has done, and if there is a future, if there is a vision, then many of the big companies or giant companies, they are also interested to take over this startup, whatever the output or whatever the benefits, commercialization possibility exists, they are ready to take it over. So this is just an example. And there are many examples that there are failures also. People may be broken heart, but then always people say that whenever you fail, you try to learn the lesson from this failure. And maybe the next startup, it will make you millionaire or billionaire, who knows. So this, as I said, that this intellectual property right and all, this was there, and World Organization also has started WIPO just to protect. And if you do not protect, then you don't feel secure, somebody will steal. And that way you will lose interest and motivation. So my message to this particular audience and my students that while doing the research, first you try to develop your own understanding and knowledge, what is going on in this particular field and why it is a challenge in terms of the technological, in terms of the basic scientific understanding. If you feel there is a scope, please put your energy, effort, and all sorts of kind of support will be there from the institute. There is a proverb. They say that if you are trying to put your energy and effort 100%, then whole universe will conspire to make it happen. So believe that, and if you go ahead with that slogan, I am sure this workshop will be really successful in terms of the conveying message and educating the young minds. I will not continue further because I have been given 5 minutes, but now that the director has not come, so I have taken a bit liberty. Today is the Valentine's Day. In the Western world, it is called the love. It is a day of love. But in the Eastern world or Eastern culture, we will make it like a love and dedication towards the IPR, intellectual property right, originality, innovation and creation. So with this message, I wish you all the best. Thank you.
Thank you so much, sir, for motivating us and encouraging us to start a startup and file IPR. Now I would like to invite Professor T.K. Nandi, Director of DIA, Center of Excellence, IIT, BSU.
Good morning to everybody. I think to me personally this is out of syllabus. I was not prepared to give any sort of talk. But yeah, so maybe just I'll try to share a little bit of my personal idea or my personal opinion about IPR. Basically we start with an idea, right? And if you start with an idea, it becomes an asset, and then you take measures to protect them. So that is what IPR is all about. And then there are different categories: patent, IPR, GI. So you have all kinds of measures to protect them. Some of the personal experiences that how, like, we probably talk about theory, textbook, and then the application is a real problem. So I worry more about how do we apply it in real life. So some examples probably I'll try to give you. We had been, I was working in Defense Metallurgical Research Lab, and we were working on tungsten alloys for penetrator or defense applications. And we were struggling with some of the properties. And we happened to meet one French company, Plancy. They are very famous, and they are the supplier of tungsten heavy alloys worldwide. So in the evening, we had a get-together. Two of their engineers came. They were extremely knowledgeable. So, I mustered some courage and just told them, asked them that, we have this company that produces, we have an industry in Tiruchirappalli which produces tungsten heavy alloy. So I just asked them that, we have this industry, and will you agree to audit? Will you do an audit of that company? And those two people, they were slightly stunned. Then I told them that, okay, so maybe you don't have to answer it today. Tomorrow, probably when we have a discussion, you can give your answer. So you take your time. So next day when he came, then he told that, yes, we can audit your company, but then you have to give us business. So then we asked, what kind of business do you want? At least we want a business for next 10 years. Then I told him that when we are asking you to audit, we are also paying you, right? We are paying you. So then he said, no, payment is not enough, because when we are auditing, you see their honesty. They could have always said yes and maybe done some sort of superficial auditing. But he said that when we are auditing, we are also sharing our knowledge with you. So, since if we are sharing our knowledge, then this has financial implications. So that is when I realized that even auditing, a company, a good company may not be able to do that simply because it doesn't want to share the idea. And then he made a small sentence. He just said that even we were making these rods. So before sintering, you have the shape of that rod. And he's just casually made one sentence that even the shape of that rod is an IPR. So I thought, okay, maybe it is an IPR, and I did not appreciate how can shape be an IPR. And accidentally, I happened to go to their website, and then I saw that, when I saw that shape, it was circular. But when we sinter, those who are in metallurgy probably they will be able to appreciate. We start with a circular shape, and it becomes elliptical. And once it becomes elliptical, you have to machine, you lose a lot of material. So, a lot of material wastage and all that. And that is when I realized, oh, these people are starting with, when they are heat treating, after sintering, they are starting with a circular shape. So then I understood what he was trying to say by an IPR of the shape. So you see the small things that they worry about. My own personal experience when we were young, we were, working with high temperature titanium alloy. And these titanium alloys, again, you probably require a little bit of expertise in metallurgy. These titanium alloys require sponge with very low iron and nickel, and that is expensive. A commercial sponge which has a higher iron and nickel is not a problem, but when you want a low iron and nickel, then that's an expensive material. So what we did is we just took this commercial titanium alloy, we added a little bit of tantalum, and we got some very good properties. Like all students, we were also like students. You generate properties, and then the next thing that we are trying to do is to publish a paper. So we got very encouraging properties. And then when I approached my boss, he said that this is a patentable material. I said, why? It's just an improvement in properties, right? So you have to appreciate, you are working with a commercial pure titanium, and there you are able to add this tantalum. So it has some sort of an IPR kind of attribute. It's a different matter that we never went on to publish that paper, neither we did an IPR. But you see, unless you are conscious about this, unless you are conscious about these ideas that come to you and go beyond writing, publishing papers, it will probably not come to you very naturally. So think in these directions. My friend Surya Yadav, we discuss a lot about tungsten heavy alloy, and many times, while talking itself, we get some ideas, which I feel, if the results come properly, are patentable. So protection becomes very important. And I think all you researchers, while you think in terms of publication, also when you are starting with a topic, don't just get the literature related to your topic. Also try to solve the patents. They also have very good scientific information. So you try to make a list of patents that you work with and read them carefully, and you probably will get a lot of ideas. So I think that becomes very important. The other thing, probably a misconception we had, I don't know, you have it or not, is that in the patent, the information given is wrong. Sometimes, that is a misconception. Generally, you don't read patent because the information may not be correct. And I specifically asked this person, this French person, that I asked him that why are you, they were working on some other materials also. So I asked him that why are you not patenting these material? Then he goes on to say that if I patent, then I am revealing my information. Then I, very casually asked him, I thought patent you don't necessarily give the right information. Then he said, no, the information that we give is accurate. So trust the patent. In fact, we have worked with some of the patents to, establish the shop floor practice. At least I have taken personal help, especially in tungsten heavy alloy, in one of the patents. And we, reached very close to the properties that they are getting. So the information in the patent is correct, so there should not be any confusion there. I am sure our guests who are there today, they will probably emphasize this point. So yeah, have trust in patents. And as regards, number of patents and then commercializing, yes, that will be a problem. We'll have a large number of patents and probably there will be a problem of commercialization. But I think there should be some study there as to what is the strike rate, what is the success rate. And then only, we should be evaluating whether, we are, the number of patents that we are publishing is enough or not. One needs to be considered because we are starting. So, initially that leeway needs to be given to the PI if he is publishing a patent, needs to be encouraged. So that's it. Actually, in DRDO, what we used to do is, whenever we go, the other way around, whenever we went for a technology transfer to an industry, we made sure that we write a patent first and then go for TOT. So at least that is one way. Many times professors may just simply go for TOT in hurry, but I think then he should be asked to patent that work first and then go for TOT. So straight away then you have a commercial utilization. So that is probably one way of going forward. Thank you. Thank you very much.
Thank you so much, sir, for your kind words. Now I would like to invite our today's speaker and IPR expert, Dr. Shweta Sharma and Dr. Geetika Soyal on the dais for the felicitation by Professor Rajesh Kumar, Dean R&D. So, okay. Now we break for the tea and all the dignitaries and participants are requested to kindly proceed for the tea and be back by the 11:10 a.m. the first technical session of the workshop. And also I request everyone to be present over here for all the sessions in order to receive your certificates for the participation. Thank you.
Uh, on behalf of the IPR sales and the coordinating the sessions on Dean R&D, I would like to thank our Dean Faculty Affairs, Dean R&D, Director of the IDEC, and Associate Dean, and Director of the DRDO Center here for presenting here and gracing our program. Thank you very much, sir. Now I will be inviting you for the tea. And all the students should remember that you have to sign each and every session. Those who will be signing each and every session, only they will be getting the certificate for this workshop. Thank you very much. We will be coming back in 15 minutes. Thank you.
Yeah. Thank you.
Hi, good morning to everyone. All right.
बैठ जाओ बैठ जाओ बैठ जाओ
Should we start? Is everybody around? Yes, that's great. All right. So, first of all, I'm very thankful to all the organizing committee and to all the seniors here from whom we can learn a lot. And I remember my PhD days whenever I come back to BHU. And I really appreciate Professor Pai for in continuous touch with me and to increase the portfolio of patents and IPR in BHU. So I would say that everyone is very lucky to have a IPR coordinator like him here. So having said that, what I want to do, everybody spoke about intellectual property rights, everybody spoke about the patents, why they are important. I would like to go a bit, take a step back on this and I would talk about that what all are we actually going to discuss today. So basically we'll be discussing a little bit about intellectual property rights, then prior art and patentability search, then patentability of inventions related to specific field, and then patentability of inventions related to bioinformatics specifically. But before going into those things, I would like to ask all of you that what is a property? If I ask you in simple words that what is property, is anybody there who can tell me? Just property, nothing intellectual, nothing else. Anything? What you can tell me? What is property? How do you say that it's yours? You have a phone, right? With you, you have your bag, right? How do you say that it's yours?
Because I purchased it.
Sorry?
I have some legal document.
Legal document for
For the
purchasing it, right? You have a document. You have the ownership of this. And that thing is in your possession, right? So, that's why you say that it's your property. Correct? Very right. Now, property, if I say that refers to a legal rights over something of value that can be owned or controlled. Right? You have owned it and that's your property. It can either be tangible or intangible. Does anybody know what is tangible and intangible property? Simple words, tangible is anything which is touchable, intangible which is not touchable. So the property is like you have your house, you have a vehicle which you can touch, you have your pen in your hands, that's your property, right? The tangible property. But if we talk about intangible property, what that could be? Any idea? You cannot touch, but that's still your property. What is that? Huh? Sorry?
Idea.
Something emerging from your absolutely intellect. Anything emerging from you can't touch it, but still your own property. So if we talk about the categories of property, real property, like real estates, the buildings, your house, your flat, your university. Personal property, the movable assets, their phone, your vehicle. And then intellectual property, which is non-physical creation of mind. Anything coming up from your mind is your property. And which is the property which majorly we fail to understand that it's our property and we have to protect it the way we protect our physical assets. Am I right? Sometimes we just simply say, sometimes people just make a chutney, I would say, but we as a patent attorney and a scientist, we call it as a composition. We do not call it as a chutney. right? Because you have made a specific amount of coriander maybe or a mint maybe, and you have come up with something specific which nobody else has done. Agree with me? So I never say that you have to do 5 years of long research to protect something. Anything which is coming from out straight from your mind, which is solving the problems of the people, and if you are addressing some problems, then it is an intellectual property, right? So as I said, the ownership rights, you are having the ownership right, and that's why it's your property. So let's revise this: property, tangible, non-tangible. Tangible would be movable, not movable, and then intellectual property. Clear till this point?
Yeah.
Clear? So anywhere if you feel that you're not able to understand anything, just stop me and ask right there. Do not have to wait for the end of this session. Ask me so that it is easier for you to understand the questions and the responses later on in the session. So as I said, now we spoke about the property. Now it comes the intellectual property. As I said, intellectual, if you break these two words, intellectual is anything emerging from mind, intellect, or the creative and cognitive abilities of a person. Ownership, possession, or something which you have the right upon is called as the ownership or the property. So intellectual property. Now, if we give a right, legal right or enforcement to this property, what it would become? Intellectual property right. Okay, because that right has been given to you. Now, if we add all these three words, intellectual property right, so you know the meaning of intellectual, now you know the meaning of property, you know the meaning of right. So if you break these three words, we'll come up to the thing that anything which arises from your brain, it is your property, and to make it your property legally, you have to have a legal document, you have to enforce it on your name, and that would become your intellectual property right. Okay? Let's be interactive, otherwise you won't have fun while I'm talking. I'll just say something and please come in front. I'm not going to take any lecture here. It's just an interactive session and you can talk anytime. Stop me and talk to me. Otherwise the purpose would not be, fulfilled. Please come on the front seats, please, all of you. That's great, wonderful. Wonderful. Yes, I'm waiting. All right. Perfect. So, I hope everybody understood the terms intellectual property rights. Now, there are different types of intellectual property rights. Right? So, how would I start it? Different types of intellectual property rights. Why I am saying this? Because sometimes you have a scientific invention. Sometimes you can see that, okay, fine, I have a kind of drawing in my mind. For my startup, I have a logo, right? Sometimes you can have a, intellect like that also. So that's on basis of that, the intellectual property has been classified into multiple categories. What is that? The first one is the patents. So patents is the majorly done for all the technical inventions, right? If you are doing your master's in science and PhD in science or any BTech, MTech, whatever, in scientific field, then you will most likely be going for the patent because you will be developing a product, you might be developing a process. So you will be going for patents. Having said that, this never means that you can only go for patents. So sometimes the question rises to us and sometimes the inventors, they feel that if I'm going for patent, I should just be doing the patent only. This is not the case. You have a patent, you can have a trademark, you can have multiple other IPR aspects also protected on your name for the same product. Okay? So never think that you can just go in for patents. Always ask your patent attorney, can I do some other IPR on this? Can I protect it? Right? So number one is patent if you are in a scientific field. So we will be learning about the patents in detail throughout the day, and so I'm not emphasizing much on this. The next one is trademark, right? Anybody knows what is trademark? Again, whenever IPR comes, just break these words, right? Trademark. What does it mean? सबने देखे आप सबने. I am sure you have these trademarks all around you. Anybody?
Logo.
Yes, logo.
Specific brand name.
Yes, of course. So, do you guys like KFC, McDonald's? Do you like Adidas, Nike? What are all these things? These are all trademarks. All right. You like Nike shoes, okay? But Nike is written nowhere. It's just a sign. How do you recognize that, okay, you have to go to this showroom only? Just by seeing that sign. Am I right? If you see that McDonald's, that sign, yellow and red, you do not bother to read all McDonald's. You just see that sign and you go. That's the power of a trademark. The consumers, they just go by that sign. If a sign for Nike is there, if a sign for Uniqlo is there, and half-eaten apple is there, they do not want to tell you, they do not need to tell you that it's Apple product. Am I right? So that's the power of trademark. So if you want, so I'll be just discussing, in detail about these ones. Then in trademarks, you have a logo mark, like ISI or TCS. So we call it a word mark also, like the way you write the TCS, LNT. So these are all part of trademark. So any kind of things which is representing visually your product is the trademark. All right. Then comes copyright. This is very simple. Copyright everybody knows, right? Anything you have written, any artistic thing, literary thing, that would be protected under copyright, right? So any poem you have written, any story you have written, any article you have written, so that would be protected as a copyright. Then comes industrial design. This is also very important thing. So any design if you want to protect, you are sitting on this table and you want to protect the design of this particular table. If it is unique, novel, and it fulfills the criteria of this particular industrial design, you will be granted the protection for this design. And if anybody else is making the same kind of design, then you can sue that person and you can ask for the damages. I'll give a very nice example, just came across a few months back to us. There's one of our clients who are into making these food products and all, right? So they were making ghee and they claimed and showed by the data that it's a cholesterol-free ghee. And we just studied and we went into that and we just checked it that the cholesterol levels are very, very less. So that would have been a very great inventions, right? So we said that, all right, bring that ghee to us. Like, how does it taste? If the people want to have ghee, they should have a taste of it, right? So they brought it, and the dabba they were bringing, that box, that was also unique. They packed it in such a way that it can travel miles and miles. So we were discussing about the ghee, but my focus was on that dabba only, So I said, do you want to protect that dabba also, the design of the dabba? He said, is it possible? My wife has just simply done it so that it doesn't spill out. I said, yeah, you can do it. She has good brain, so she should also have some credit to be good. So that dabba we protected under the design and the ghee was protected under the patent. So one product you had these two IPR, then they had specific name, a very well-known company. So they had that name. Then they have a specific kind of name on it. So that is the trademark thing. So they had copyright, trademark. They had composition patent. They had the design patent, right? So industrial design is anything. If you are making any design, simply design. Nobody is going to ask you any specification. That if I have made this chair, what components you have used here, what GSM of cotton you have used, nothing. They will just see the design and they will give you a industrial design bracket. Geographical indication, I'll be talking about anything which is growing. And I would also say that Banaras is one of the most on top where the geographical indication products are mostly, protected. So anything which is grown in a particular area that is being given a GI tag, right? Banarsi sari, Banarsi pan, multiple things. And Banaras is one of the hub for all the GIs. And I'm really happy to be here and to say this on this land that Banaras is one of the most, on top place where the most of the GIs has been granted. Then trade secrets. Trade secrets are the protection given to few products for which we do not know exactly the constituents. The constituents and the composition is being kept secret, but still they are protected until unless somebody cracks it. Okay, so these are the types of intellectual property. Most of the things I have already told you, but let's quickly go for it. So as I said, the trademarks or intellectual property rights which is granted by the government to an individual, to a business, to a startup, to a MSME, anything which is like unique logo or unique anything. It can be a distinctive word. It can be a name like Microsoft. It can be a symbol, right? Like McDonald's, KFC, or any Adidas sign or a Nike sign to distinguish its products or services from any other entity in the marketplace, which says that it is different than any other thing which is present in the market. Right? It's a distinctive sign. I'll just quickly go through it. So a word Coca-Cola, Microsoft. So it's a word mark. Okay? So this is also falls under the trademark. Then letters IBM, HSBC, BMW. Then a logo, ISI or Adidas logo or Nike logo. Any certification marks like AgMark, Hallmark. These are all protected under trademark. Then any service mark like CSIR, NCRT, SBI. These all protects the innocent publics from buying goods of second-rate quality, right? So they have protected it. If you are buying an apple, so you are sure that sign was there and you are sure that this product is authentic, right? Okay? Then comes the copyright. As I said, an intellectual property right granted by a government to the author of an original literary, dramatic, musical, artistic or other eligible creative work. So anything which is related to this, you have written something, lyrics, any poem, any song, any story, anything you have written would be covered under copyright. So the copyright is all literary work. It lasts for the author's lifetime plus 60 years of the end. So at the moment if you write something, so till the life you are alive plus 60 years of that, it would belong to you. It's punishable to infringe the copyright. So if somebody, suppose there is you might have heard about multiple such kind of things that a song was written by one person, it was composed by somebody else and somebody just stole it, right? So it's a punishable offense. If somebody is writing and you are just stealing it and publishing it by your name, right? Now it's very understood that to copy or not to copy, so you should not copy actually, even if you are writing a manuscript. And sometimes what we did, if we are writing simply a review article, what we do, we just take up the pictures, the figures from anywhere. So generally in our field, in scientific field, nobody says anything. But always try before taking any picture, before taking anything, dramatic or something. So, and if you are copying exactly the same thing, ask that author, write down a mail to that author or a corresponding author for the permission. So that, and if you do not get the answer from that corresponding author or any author, just acknowledge them and mention that this particular figure has been taken from this particular paper, right? So that's also an offensive and punishable offense, I would say. Avoid plagiarism, we all know that, any abstract summary, so you should ask before you use. Copyright violation could lead to criminal and civil courts also. It could lead to imprisonment too. So if somebody comes up and complains that you have exactly taken the same thing from their content and you have not asked them, you can have a jail also, right? Always acknowledge and prior permission. If you are not getting sometimes the authors, they do not respond. So if you're not getting the permission, always acknowledge them, right? So this always you have to remember. Industrial design I already explained in detail. So just the design, if you're making any chair, any bowl, anything which have a distinctive features, then you'll be getting a grant on that. And if anybody else is making that, that person can be sued by you and you can ask the damages. Right? Geographical indications, as I said, the name or sign used on goods originating from specific geographical. So I have a few pictures here. Does anybody know that Petha, the Petha is famous from? Wonderful. And this sari, and then oranges from? Any five thing I would like to know from Varanasi. What is famous from here? Anybody? One by one. Sari, yes.
Lal Peda.
Malayu, yes. And? Yes, think multiple things are there. Oh, okay. There are multiple things. I'll show you a list. There are multiple things of Varanasi which are famous and GI tagged like anything. Alright. So these are some different GI tags which are provided in India. These are very less number I am showing you. Banarsi sari from Banaras, blue pottery, the Chandeli fabric, Madhya Pradesh, Kutch embroidery, Solapur, Kolhapuri chappal, everybody knows, right? MP ka what atta is famous?
Sharbati.
That's been given a GI tag. Then anything else, I mean, even if it's not there in this, Pashmina shawls. So these are all GI tags. So the GI is not like rest of the IPR has been given to an individual, right? Patent will right? There is one like single person. GI tag is given to a group of people. Like in Banaras, I know few people who are working on this Banarsi sari, and they have been given that whole society just to give some respect to those bunkar and to give some financial help to those bunkers who are really working hard making the Banarsi saris, right? So that Banarsi sari is also given a GI tag, and there are multiple other things from Banaras which are being given. So anything which is given to a specific product from a particular place would be GI tag, and it is given generally to a group of people, not an individual. This is a major difference of rest of the IPR as compared to the GI. Trade secret, as I said, some of the companies, so like I would say the patents, you want to disclose everything, right? The patent office wants that you should disclose everything in your application so that a person reads that and replicate your research. If there is anything missing, the patent office will raise objection. But sometimes there are few compositions, they say that I do not want to disclose anything. The patent office says that okay, the day it would be disclosed, we don't take any responsibility to protect it, and if you come to us that and you want to sue us, that particular person, we won't be able to help you because you have never disclosed it. So any of your employer, because of anything. So that's called as a trade secret, and the best example of trade secret till now is Coca-Cola. So multiple of people have tried, decoding the composition of Coca-Cola, they could not, right? So that's one trade secret. So if you do not want to disclose all the details of your compositions, you can just go for trade secrets, but it's like the burden of proving this on you only, you won't be able to sue anybody because you have not disclosed anything, right? Now, as I said that I'll be talking more about patents today because most of you are related to the science background, right? But at the same time, I would again say that one product can have multiple IPR protections. So always think about other things, and if you're not able to think, please connect with us that what else can be protected rather than just focusing on patents. What is patent? Does anybody has a patent here granted or filed? Because we have filed multiple applications from BHU last year. Multiple. Anybody who has written or who has reviewed? No? No one? Yes, you? Yes. What is patent? If I ask you, like, what did you understand while reviewing it, or during the process. You have simplified at the moment? Okay. One patent. And if I say that the major one difference between manuscript and patent, what would you say? Okay. So the patent and manuscript, it is very important to understand before I jump into the patent thing, that there is a major difference, one major difference between a manuscript and a patent. Manuscript, we generally as a researcher, we want to just publish high impact peer-reviewed journals, right? We just least bothered about the patent. We used to be, now we are doing it. Even I used to do that I have to publish like JBC and those all papers. I was least bothered about my patents. So, the patent is actually more towards the commercialization. That's how will you get back the efforts you have put in, right? Manuscript you have made, you have published an international paper, it has been cited, it's very good for your career. However, you have worked for 5-7 years, you have invested money, you have invested time, you have invested efforts. So, the patent is a way to get back those revenues. Getting my point? That's one major difference, and that's why if I'm saying that there is a major difference between manuscript and patent. So the major difference is the patent would tell you actually what you are claiming and how you can give a product or a process to another person to commercialize it, to make use of it. Getting my point? So this is a major difference, and whenever you are writing down a patent document or if you are giving us the details, always think that this is the way a patent attorney thinks, that what product we can take out, what method we can take out so that it becomes sellable. So that the similar kind of, one of the professor at the moment, they were talking about that L&T thing. Did you guys hear that? How important it was? So the bigger companies, they come up and take your ideas and they give a huge amount of revenues and they sign a contract with you, even for a small idea, which is making big difference, of course. So patent is basically exclusive rights given by the government to the inventor. So it's a legal document for inventions relating to a new process or products. So process may be any method, anything. Products could be anything, any composition, formulation, any device, any apparatus, any system, anything. So that would be considered as a product. Of course, it's a legal document issued by the patent office, can be sold or licensed exclusively or non-exclusively, or barter system. What do you mean by that? Okay, fine. You have a legal document for your home, registry paper. Okay? Then what you do, you can sell it. Of course, you can sell it if it's on your name, right? If you do not want to sell it, you can give it on rent. You can give it. If I live in Delhi, one of my friends lives in Noida, and my job becomes in Noida. I say that, okay, you live in my house, I would live in your house, let's do a barter system. Alright, I do not have to pay for rent to go to Noida maybe, and then you can come to Delhi because your job is in Delhi. That's a barter system. Like, it used to happen in the old ages, right? The people used to give rice, and in exchange of rice, in villages they used to give us, dal, something like this. So that's a barter system. So you have one patent, you think that your patent, if it gets worked with the other patent with somebody else, you can combine or you can exchange the patent also, right? So this patent, just consider this as a genuine your property only, which you can sell. Suppose, why would you sell your patent? Any idea? If I ask that you have been granted a patent and you can just sell it, why would you do that?
To decrease monopoly.
Sir, you are not allowed to speak.
To decrease the
Yes?
monopoly. To reduce the monopoly.
Sorry?
To reduce the monopoly.
Monopoly is one thing, okay. But why would you sell? Money is one thing, yes. You would also sell because as a researcher, whatever we develop, that's on the benches. That's not on large scale. And do not have that, web facilitation centers, right? So if you have developed some, suppose you have developed a media to grow some systems, to grow cell culture, suppose you have developed, right? That cell culture you have developed in a lab. But you do not have infrastructure to develop on the large scale. So now either you just develop that infrastructure, is it easy? What would you do? You will find out some person who is into this only, some company who has that infrastructure. You will find that person, you will either ask him to take your patent, granted that right completely, license it completely, that okay, I am just selling this to you and give me a lump sum amount. Okay? If you do not want to sell it, you can license it to 2-3 different companies. Okay, fine. Now I am done with research. I will not do any research. I have been granted this patent. Take the rights. I'll just give you this paper. You can work on this patent. I'm giving you this right. And you can work on these particular inventions and you can just keep giving me the revenues. So by the time you are developing other cell culture, you are getting the revenue from your previous patent. Getting my point? So this is how you can utilize your patent. So you can sell it. Suppose you think that I don't want to take any more tension, that when is it expired, when is it going to be, expired or given to somebody else. I just want to sell it and I want to focus on some other research. Or sometimes you want that I can give it to some different people, but I should have the whole right. Okay, so you can just use your patent like your natural, real property. You can sell, you can rent, you can barter, anything. But the major thing is, it's for the 20 years from the date of?
Patent filing.
Absolutely correct. From the date of filing, but not from the date of grant. So the day you file, your time starts from there only. So from that day, 20 years, nobody can take that right from you. One more thing I would like to add here, that most of the companies, what they are doing at the moment, by the time it's going to be 20 years, the 20 years, the things get changed like anything. Agree? So what they do in that direction only, they just keep on doing research, right? Suppose my lab, it was working with the methyl glyoxal. So I have published many papers on that. So we were working on that. But altogether, after publishing one paper or getting one patent, I can't start something else immediately, right? Because I have a domain. I had been working on glyoxylase, methyl glyoxal and all those things in plants. So I would find out that what better I can do in the same direction and what else additional things I can do in a similar line which would grant me another patent after this, right? So don't think that you have published one thing there. So suppose methyl glyoxal I had been working, or glyoxylase I had been working. We found that the process of isolating it. Then we published one patent, on that. Then another patent we published the method of developing the transgenics. So I had 2 patents during my PhD. From there I developed interest on IPR, to be honest, and then I jumped into IPR after 14 years of career in academics. So one thing you are doing, you have to just think that what else can be patented. So those patents are for 20 years, but that doesn't mean that if you are working and you have one patent, then you should just sit and wait for 20 years. And then after 20 years, you will do something else, right? So this has to be remembered. After 20 years, you will not have any right and this invention would become public and anybody can use it. Another major thing, that it's geographical territorial. Means what? That this would be granted to a particular country. So if you are filing a patent in India, this would be protected in India only. If you are not filing in US and you are going, somebody else is using in US and you say that I would sue you, that won't work. Because you have not got a protection there in US. So wherever country you want to file, you can just file in those countries. There is another method of international filing, which my colleague Dr. Gitika would be talking about the whole international and national filing in the later sessions. But this has to be remembered. This should not be, if you have not filed somewhere, it is not protected. As simple as that. Right? Now, why should you patent your invention? I have given you multiple reasons that why you should patent. Right? So would you buy a house from somebody without that receipt, we'll never do it. But we forget to take protection for these things, for our invention, right? So, why should you patent your invention? So that, number one, it's your brain which was involved developing that. You should have a protection, you should have a monopoly on that. Number two, to get a revenue on that. So I'll just go through few very specific things that why you should get a patent. Prevention against leaking or unauthorized use. So suppose you have simply made a, what should I say? I'll again give an example of chutney, right? You're very good in making compositions of those dhania mirchi, and your chutney becomes famous. यहाँ पर भी some place must be having some kachori wala which is very famous. है यहाँ पर कुछ? Definitely, right? So you are going there, and he sells a lot in a day, suppose. Now he has made that chutney using his brain, and after 7 days, 8 days, I'm a good cook. I can eat every day, and then I can just reverse engineer that what he might have used, and I can make the same chutney. Would his sales suffer? Yes or no? Sales suffer, right? Simple chutney. I'm not even talking about any rocket science. Would his sales suffer or not? It would suffer because somebody else, and that particular person who invented that composition, can he do something? Because he doesn't have any protection. He would come to me and say that, why have you made a chutney like me? I would say, I would make. What will you do? How can you stop me? Show me some paper that it's yours. We used to say ना बचपन में कहीं लिखा है क्या सीट पे तुम्हारा लिखा है बोलते थे ना तुम्हारा नाम लिखा है इसमें हम ही बैठेंगे. So this is how it works, right? So if you do not have taken protection for that, then it is not yours in simple terms, right? So the patent or these things, IPR is to be taken to prevent any unauthorized use of your invention so that you can stop people. Prevention by secret exploitation also, even if somebody is secretly using it, if you can find, you can sue them and you can ask for the damages. Return on investment, it is also one thing. That chutney wala, again I would come to that example, that what he can do if he has a protection and somebody else wants to take a franchisee, what he can do, okay fine, I'll give you the recipe of this chutney, but for each cell you have to give me the 10%. Possible? Then what is he doing? He is not doing any extra effort. He has a simple shop, he has already made that chutney. But what he is taking? He is taking a return on his investment without doing any effort. The next person he has given the franchisee and he is taking the revenue. Getting my point?
So is it different from royalty? Is it different from royalty?
See, royalty is generally given by the government. If government takes up your patent, so this is the royalty they give, right? Suppose there is a disease, COVID was there, right? So I wrote down the patent for Covaxin, which was developed. And if Covaxin is being given because it was necessary to be produced in large scale and it was necessary to be given. So the Bharat serum, they never had this say that no, I will not give or I'll just sell it on this price only, because then on those kind of things government takes up, because the most important thing is to save the citizen of a nation, right? So they take up and then they say that okay, give this to us and we will give you royalty. So that's the royalty. Okay, revenue is something what you generate by selling, by licensing your patent. Okay, I hope it's understandable by then. Any questions? No? Good. Enhances business market value, of course. Does it? If you have a patent, does it enhances your business market? If you see that Nike sign, do you even bother to read that whether Nike is written or not? Or you just enter the showroom? Sign is enough, right? So that enhances your business market. That chutney wala, again I would come back to that chutney wala, that if somebody is there and if they know that okay, he is on the central Banaras and I want to open a shop in somewhere outskirts of Banaras, he would take that chutney recipe from him, he'll take the franchisee from them and he will expand his business and he'll take the revenue. And investors would also come. They would also, put money in his business, right? investors would be saying that yes, this is being protected, nobody else will have it. So this also enhances your business and market value. Patentee can sue the infringers, of course. If they know, they can sue the infringers, right, and ask the damages. So this is again the same thing. I am not going to repeat this much. So a patent gives its owner the right to exclude others from making, using, selling, importing, anything. Nothing can be done without the permission of a patent owner. Sorry. Then the patent rights are granted in exchange of enabling the public disclosure. So you have to disclose everything. Now steps involved in patent prosecution. So this is very crucial thing. I would like all of you to just pay attention to this, that how this procedure goes, because why I have added this sign, because there is a very vague idea that what happens actually. Okay, fine, what would happen? So very first question I get from the inventors, if they are calling me, how does it happen? Like how do we start with? How do we have to do it, and what would happen after this, right? So the steps involved, I would like to say that I have shared these PPTs with Mr. Bhanu, and nobody needs to write this down. This would be shared, right, Dr. Pai and Mr. Bhanu? That can be shared with them, right? So that's why I have shared, so that you do not write and just listen to me. First idea, very first idea for any invention is idea. You have conceived, right? The second very important thing is to find out whether that your idea is unique or not. Would anything be given a grant which is not unique, which is not novel? Would it be given the grant? No, right? So rather than having an idea and immediately starting experimenting on that, it won't give you much results. Why? Because you do not know that what is there around. Okay? So what you have to do, you have to search that what all is present. Now, as a scholar, what you generally do, you will go to Google Scholar, you will go to PubMed, you will go to NCBI, you will search. But from there, can you get a patent document? You just get a published document, research papers, right? But a patent document need not to be there, and your invention might be there in the patent document. So, in the next session, I will be showing you how you can find your invention is patentable or not in terms of the patent documents for free. You do not need me, right? You do not need any patent attorney. Just the way you search on your Google Scholar, just the way you search on NCBI, just have to make the keywords. You can put those keywords, you can find all the relevant patent documents related to you. So now the very first thing, I would be really happy when you go back, and from now onwards, you along with doing the Google Scholar, you also do the Google Patents. And I would be really happy, and I would consider my lecture to be successful. If you do it along with finding out the research paper, you also find out the patent document, that what all patents are there. So I will just in the next lecture let you know that how a patentability search is being done. So you have done the patentability search. Now you know that, okay, your invention is unique. What would you do? Proof of concept. That what you have thought is actually working or not. Correct? So the proof of thought would be there. Excuse me. Then you have a proof of concept. There are two things here. You have a proof of concept. Now you know that, okay, fine, this would work, what idea I had. Suppose you have, you're thinking of making a composition for anti-hair fall. So you have done it, you have that composition, you have tested on few of your friends, and you saw that, okay, anti-hair fall composition system is working. What will you do? You will start drafting and thinking of filing a patent application. So there are two ways. If you think that you need some more time to develop the data. Thank you so much. So if you think that you need more time to develop the data, you can just file a provisional application and keep continuing generating the data. So after provisional application, you can file a complete application after 12 months. I mean within 12 months, I would say. Right? So 12 months are enough to generate data and to show that this composition is working. So that's called the provisional application. So you have filed a provisional application, And then you have 12 months, you can generate the data. Why are we filing a provisional? Why are we not waiting for complete application? I mean complete data to be generated and then file. Any idea?
So other person can, like, other groups can also.
Absolutely correct. It's not like that only you are working on that. Or maybe you have spoken to somebody that I am thinking like this. The other person is also thinking the same way. And he is also generating the data. Right? But once you have filed a provisional application, then that's your priority date. Okay? And priority dates really matters a lot in the field of patents. So the priority date is secure. Now, even if after one day somebody is filing, your application is on priority. And the next application, if the similar data is being there, that would not be granted. And yours would be cited as a, that already present data. Okay? Right. One more thing I would like to say here, that if you are publishing, then also even your invention can be cited as a, prior art for yourself. They do not consider that it's your data only. And so that also has to be remembered, that before publishing you need to file. Now, as per the new amendment, if any of you have published an online paper, and that's not even 1 year, so 1 year grace period has been included as per the patent office, and you can file your application within 1 year, right? So in that case, your publication would not be considered as a prior art for you. So once everything has been done, you have decided, so you will draft an application. Drafting is a skill, I would say, and it's an art, it's not science. So even if I am drafting an application based on some immunology or molecular biology, I call it as an art. It's not science. Okay? So you have to draft your application in such a way to come out that what product or what process you are providing and how it is different than the products and process which are already there in the prior art. So that way you have to move your application right from the field of invention background till the end. Right? You have to draft the application like that. Once the drafting has been done, you will file the application, whether provisional or whether complete application. Then it would be published. It would automatically be published within 18 months. You do not have to do anything. However, most of the renowned institute, including BHU, IIT, we are filing the expedite application for publication, in which the application is being published within a month. Definitely it incurs a little bit of prescribed fee and prescribed forms, but it would be published within 1 or 2 months, right? So there is a huge difference between 18 months and 2 months. Sometimes the application has been published in 1 month also. Once the application is published, you can file the request for examination. However, I should say it in a different way, that you can file the request for examination along with filing the early publication form. So request for examination you have to file. Otherwise, the patent office, anywhere in the world, the patent office would consider that you just want the published document. You do not want this to be examined. And in patent, the published document doesn't mean a lot. Okay? So you have to file a request for examination. What would happen? You have filed this request. You are requesting the patent office that examine my application. They would examine it. So there are multiple examiners in the patent office, and your application would be assigned to one of the examiner of your domain. He would examine your application in terms of whether it is novel or not, whether it has some industrial applicability or not, whether it has some inventive step or not, and on that basis he would provide a first examination report. Why it is called first? If it is not satisfied, he can issue a second examination report also, right? So in first examination report, he will be giving all the details that why your invention is not novel. He will cite some prior art. He would say that, okay, this particular invention in D1, in document D1, the prior cited art, it is also saying the same thing. Why your invention is different, why your invention is novel on the basis of this. And that's where the importance of patentability search and prior art search comes up. So if you have done a patent document search also through the free databases, you might also have found the same document, right? and then you can clearly say that what is the major difference. Okay, so that's the benefit which comes from doing the prior action you did. The first examination has come. Now the onus is on you only, and now you have to respond within 6 months from the date of issuance of the first examination report. How would you respond that? You will prepare the response as per each objection. If he has said that document, there is a prior document called D1 which is saying the same thing. What you have to say that my invention is this, the other document is saying this, and here is the difference. Sometimes you should also tabulate it, the exact differences. You will submit this FPR response by applicant, and then a hearing comes. In most of the cases, another call from the examiner and controller comes. That's being called as a hearing. But if examiner is really happy with your response, they can grant the patent that moment only. But they rarely gets happy, to be honest, and they do not exactly grant it immediately after filing the response. In my whole, I guess, 8-9 years of experience, there are hardly 6 or 7 cases which were directly granted. So in most of the cases, a hearing notice comes, and hearing notice, again, if he is satisfied with few of the things, he would ignore that. But if he is not satisfied with for other things, he would again mention that, okay, I'm still not happy, let's talk face to face, okay? And that is always in a virtual mode, and they send a WebEx link. We, as a representative of our clients or inventors, we discuss with that. If inventors want, they can also be a part of hearing, and if the controller or examiner allows. So after hearing, we discuss everything that what could be done, and after hearing, within 15 days from the date of hearing, we have to again submit that what was discussed during the hearing. Okay, everything in detail, and that is called as the written submission. You are submitting in writing. That's called the written submission. You will just submit your submissions, whatever was discussed during the hearing, within 15 days. And if you have not submitted within 15 days, your application is abandoned. There is no extension here. Okay? Number 1. Number 2, if you are not able to attend hearing, prior to the 3 days of hearing, you have to inform the controller for adjournment. You can't do like, so tomorrow is your hearing and today you are saying that I do not want to do hearing. Okay, so prior to 3 days. So these are very, very stringent deadlines, and you have to remember this. If you have not filed FPR response within 6 months, you can take some extension, but that also you have to, prior intimation you have to give. If you have not submitted the written response, then application is abandoned, right? So this is hearing happens and the decision comes, either refusal or anything. If it is being granted, good enough. If it's not being granted and you still think that okay, there is something wrong and our invention was really great. So what you can do, you can file a review petition to the same examiner, okay, within a month from the date of decision. You can file a review petition saying that okay, you have rejected our patent on these bases, but we do not agree. We do not agree, and we are again giving a review petition that you should review this application and give us decision. Suppose again he has rejected it. Then another option is to go to appeal, and that happens in High Court. Then our litigation team I go as a scientific expert, and then we fight in the High Court for appeals, right? So it's not like that the patent is being rejected, so the case is being closed, right? You have few other way also. Now, as I said, that what exactly you can patent? A product, process, machine, device, any composition, formulation, any growth media if you are having, provided they have novelty, non-obviousness or inventive step, and industrial applicability. Now, another very important thing is that it should not fall under the patentability clause under section 3 and 4, right? Now, this would be discussed in the next session, but novelty, inventive step and industrial applicability, and section 3. What is that? Novelty is something which is, if I talk about in the field of patent, So if I just ask you that what is novelty, or how would you explain that? Anybody? Novel. Anything is novel.
New.
Okay, yes.
Never performed earlier or have evidence.
Yes, yes, absolutely. But when we are arguing, like suppose, as I said that the examiner gave a first examination report and he has said that there was no novelty. What as a patent attorney we try to argue? We find that document and we see that our invention was having three components, A, B and C. The other invention, what he has cited, he has a composition having A, B and D. So the C is not a part of that. C is the part of our invention, but D is not a part of our invention. We say that all the essential features should be copied in our invention. Then only it would be considered as not novel. Right? Because it is novel. If D is not present, how can you say that it is not novel? Right? Only A, B is common. C is not common. Right? So novelty means that if any paper which is giving the exact thing, then only it is called as a hindering the novelty. But if your invention has anything different, it would be past the exam of novelty. Now the major objection. So novelty we argue. If it's like not there, then we can't help. But novelty we argue well. The major problems comes when the inventive step objection is there. Inventive step or non-obviousness. If I say something is non-obvious, what do you mean by that? Non-obvious. It is not obvious. Means what?
It's not essential. Whatever you add on the B or C part is not essential, but you have to look for the nuance. That's why it's not.
I'm simply asking the meaning of the term. Non-obvious.
Not necessary.
Necessary, I would not say. Not obvious. I mean, something is, when we generally say, obviously, this is very obvious. We say this, right? So something, if somebody is slapping somebody, he gets angry. It's obvious. I'm asking what is not obvious. If he doesn't get angry, right? Or irritated. Not obvious means which is not a general outcome of a person, right? So if anything which is not understood or which is not be expected from the other person. For example, we used to have a phone, right? In 1999, just a phone. Did we have camera or screen or anything? No. Somebody came up with that phone along with that camera. Was it obvious? When we had phone, did we think that obviously it should have a camera? Did we think like that? Never. That's non-obviousness. So that inventive step should be there. That you have taken a step towards the invention. Right? It should not be obvious. And small steps you have taken. So it would never happen that a particular invention is not there. Phone was there, camera was there. But they were not made obvious. They were not together. And whether taking them together is giving any help to the general people. Right? You can combine anything other than camera. Phone ke saath, if you are combining a bucket, would it be any help? So that would not be inventive. Right? You are combining phone with camera, that becomes inventive and non-obvious. So non-obvious means which is not thought by a general person who has the same skills as you are. Right? So that's called the non-obviousness or inventive step. The third thing is industrial applicability. If you are making superb invention, but it doesn't work here. Like suppose like people are making minus 30 degrees jacket here in Delhi. So it is not that much necessary here. So in India, he might not get it based on the industrial applicability. But how will you do this? If you are filing it outside, maybe in Canada or somewhere else, Switzerland, maybe it's important. So it should have, in which country you are filing, it should have an industrial applicability. So it may be novel, it may be inventive, but whether it is having any industrial applicability, does the people in that particular country, they require it? Do you have any business here? No. So that's also important, that it should have an industrial applicability. Yes.
My question is, it is not applicable for India, but we can produce here in India and we can export them to the other countries. So that's why for that purpose industrial application is there. But we have the source one. But for source patenting by another person. So we should have it patented
somewhere else, keeping the उसमें you have to remember that because you are a national of India, you have to either take permission from Indian Patent Office to file directly outside, or you have to file an application here, because this invention is being originated from India. So either you file an application here, don't take it like on the whole prosecution, you can just let it be abandoned also, but taking the priority from India, you can file in the other countries. But you have to file here, or else using Form 25 you can take permission. So Patent Office would go through your invention and they would understand, okay, -30, -40 jacket is not going to work here, and they will give you permission. So that's called the Foreign Filing License, FFL we call, right? Form 25 has to be filed, and generally within 21 days they respond. So that people and mostly startups are doing to save money, you know. Okay, then comes the non-patentability. So section 3 of Indian Patent Act, they have 10, 12 multiple things where they say that these things are not patentable. And for example, a method of treatment is not patentable in India. So if you are making a composition, you are saying that this is a method of treating. I am just treating some physiotherapy method is there, and they are saying that it's method of treatment, that would not be patentable in India. And I just come up in the next session which are the specific things which are not patentable. So I'll just stop this particular thing because I'm definitely going to discuss in the next session. I would like to show you this particular thing, that can one product have multiple in IPR protection? So what do you think? You have one product. Does it? Yes, please.
A project or product has multiple aspects in it. So
Sorry?
a project or a product can have multiple aspects in it. So we can file different IP laws.
For example?
If you like take a basic hydrogel project, it will have some cylinders, some base matrix. We can have both novels.
You can have patent and. No, I'm just asking about that. Do we have one product which has multiple IPR, which has a trademark, which is a design, which has a utility patent? Can you have? You all have this in your hands. Do you have 4? So do you think that all kind of IPR protections are there?
Yes.
Yeah, so if you have a phone, which kind of IPR protection it might have? It would have patent for? Huh? Design protection, of course. Anything else? Design, okay. Anything else? Trademark, very nice. Logo is under trademark, of course.
operating system.
For? Copyright for? So, one product, again, as I gave you an example for ghee, that was a small example. So, for one product, for one phone, you have all types of IPR. So, if I talk about this particular phone, this has trademark made by Microsoft. Lumia 650 is a product name, right? That's again trademark. Software, Microsoft WP. Chipset, that is also trademark. Then patents for data processing method, semiconductor, processor technology, OLED touchscreen. Then copyrights, then certification marks, then designs. So can you just see that one product is having so many IPR protection? And again I would see whenever you are making an invention, do not restrict to one particular IPR only, and after seeing this, you can easily understand that you can have multiple and see how much revenue you can generate by this. Yes. Pharmaceutical products, so you will be selling it in some way, the packing would be. So the packing, the instructions you have written, that can be copyrighted because it's your written. Then you have a name of that particular medicine or a generic medicine. Then you might have a logo, that would be under the trademark. Then composition of that pharmaceutical, that composition would be under the patent, right? If you have the method of developing that composition, that is again a patent. Then if you are designing a specific airtight box for that, that is design. So many, yes, you just have to think and you have to make it unique. That's the thing. Now, what I'm going to show you at the end of this session, some interesting patents. And why, what is the reason showing me here these patents is to tell you that you do not need 5 years of research for doing anything. Sit sometimes, maybe once a month, brainstorm with each other and think that what is the requirement, what is missing, so suppose you might have been reading the news these days that multiple people are missing from Delhi these days. Have anybody read that? Yeah? So 800 people or 900 people. So as a parent, we are very scared, that where is my kid? So now it's our duty to pick them, drop them because we are scared. But for being working, it is not possible for everyone, right? We cannot do it everyone. So what this problem was identified long back, and the people, they designed a smart school bag. They didn't do anything. They just took advantage of the panic mode of the parent like us. Okay? They understood that parents are panicked, that the kid has not reached. They developed this bag and they put a chip here, and wherever your kid is going, the location can be traced. Right? Isn't it a good invention? And does it need a lot of research? Just the mind. And you have made it. So bags were already there. Everything was already there. They just made a chip there. And this made multiple people's life easier. So they thought that where is the problem? They identified the problem. And then they simply found out the solution for that. And they made this bag. How much time do you think they might have taken to do this? They might have connected with a person who was making bags. They said that, okay, you're making bags, I'm giving you the contract for 50 bags, and just whenever you're making bags, at this particular place, put this chip. Did it take much time? No. But identifying the problem might have taken more time. And this happened by one of the IIT Delhi people. And those guys are hardly like 20, 21, and they brainstormed and they found this problem. And they provided the solution. So you have to identify where is the problem and how you can find a solution. The next one is even more interesting. So everybody puts alarm in the morning, right? I also put an alarm. Do you get up in one or do you snooze at least once? Snooze? Yeah, me. Let's get up. And you think that you'll be sleeping another 5 minutes, but it becomes 1 hour. I don't know how. Yeah, happens? What they did, they made an alarm clock. So a foot mat, until unless you get up and stand on that, it won't stop. And the voice would be increased like Alexa does. One way you didn't get up, it would increase voice slowly. And they made this, that once you have got up and stood over that with both the legs, not one leg that you have done this and slept again. You have to stand on that mat and then only it will stop. So most of the lazy, that person would be really most lazy, who would be sleeping again. But most of us would get up, right? Once we have got up from the bed, we will get up, right? Because it's not that easy to just put a snooze on it. The another one is again one very interesting invention for the people who have kind of OCD, who cannot. Like if I see there's a glass and there is a cup, that chai mark is there, I keep getting irritated, why this mark is there, I have to just clean it. So this cup was made, if a drop is getting down, this would just be going through that and won't make the table dirty. So these are not big invention, these are just the requirement. They identified the problem and they provided the solution, right? This mat problem is common, right? This alarm thing is a common thing. So this is how you have to think. You have to just think that what are the problems and where you can find the solution in the easiest way, right? Why I have showed these many patents, the very, very small patents, but with big industrial application, big benefits, so that even if you are in UG, MG, your master's degree, you just have to identify the problem. What we think patent would be granted if we will do 5 years of research. Do we think like that? Right? That we have to do a lot of science. We have to generate a lot of data, so then only we'll get a patent granted. No, it's not like that. There are small businesses who are not even scientists, I tell you, One of my client, she is simple, I guess, from business family, and in COVID situation, she made this aloe vera and a few things, and she made a kind of shampoo. But she had all the data. She used this on her daughter's hair, I guess. And that pre-shampoo, like we condition our hair after the shampoo, that was a pre-conditioning shampoo. She is not scientist. She has not studied science. She just made, combination, and she had the data that what combination is working best, and she got a patent over it. I'll give you an application number also of hers. And I was initially like very hesitant that why I am working on this patent, to be honest. But that was granted because it was a unique composition where she had added multiple things of the basic traditional things, aloe vera, coconut oil, and some vitamin E and all those stuff. So my purpose of telling you all this is you just think that where the problem exists and how you can find out the solution. And I am here to write down your patent. Just to do this, brainstorm among each other and find out the solution for this. What are the problems and how we can solve it. Right? So this she's selling her product. I'll give you the application number. I don't remember now because she might have trademarked it or something. I just helped her in getting the product in my previous company. But I'll give you the patent number. No sir, I'm not using that product. So I was expecting that she would come up later on and tell me that what the trademark is. But she's selling. This is what I understood last time when I spoke to her. She's from MP, Jabalpur. And initially I was very hesitant, honestly speaking, because I generally work on these, majorly the IITs inventions and all, and ICGB IITs and NITs. So that invention came up and I was a little bit, because I don't know why I should not have been like that. But then when I was just going deep into that, I thought, okay, she has also done something. It's not like that she doesn't have that macromolecular structure information and all those things. So it was granted. So this is what I'm trying to say. Just go back, think that what are the problems, identify that, and start thinking something. So this ends, my first session ends here. Anything, any question? Anybody? Any question from this session?
Ma'am,
Hanji.
suppose we discover one stapler which is already present in the market, and that stapler's music is also available in the market. Someone has taken the stapler, concept of the stapler, and introduced the music. Whenever we staple a page, the music will run. So can it be patented?
So what is the point? If it is music is being played, so what problem is it solving?
Make it unique. Like
So again, I would say that it should have some industrial applicability. So if it's making a music, what is it like? How is it better? Like what impact is going to be? Why would I?
My point was that suppose the stapler is also industrially important, the music is also important. If we copy the two concept and make something new, so can it be patented or
no? It should have. You have to prove that combining them, how it is good. Like I give you an example of combining phone and camera. It has utility, right? You do not have to carry phone and camera separately. It's just one device you are carrying and spoken.
But we can combine both the concepts.
You can combine, of course. You can combine, but it should have some, like I just saw one small invention where an umbrella has been combined with a torch. And that was granted. Because nobody thought like that, but that was a very required, like if you are running in a rainy season or something and it's dark, the umbrella, the torch would really work. So whenever you are combining, so torch was known, umbrella was known. It's not like that they were novel things, but you combined it and you have proved that it is important. So you have to show that why, what is it doing? After combining, what is it doing? And if you are not showing that, it won't be better. Can you know? No, because they have protected it under trade secret only. So you cannot do that. So that's their choice, yes.
They have to patent their idea.
Idea cannot be patented because if you ever see the patent document, you will see a 50, like if I am saying that I have combined ibuprofen and paracetamol and it is giving relief within 2 hours as compared to 6 hours. So I should provide the data. Only saying would not help, right? If you say some idea is there, but idea you have not the proof of concept, that won't work.
Can I write that idea as a novel and make it copyright?
You can write that article copyrighted, but that copyright, if somebody does the experiment on that and prove that wrong,
Like a novel.
you can copyright. Why not? Anything in writing you can copyright.
Ma'am, recently,
Yes?
this one more question.
Huh.
The thing is that copyright is literacy and dramatic everything. What if a professor or any dancer has their music steps or technique and it's like so with Michael Jackson that can be copyrighted?
So Michael Jackson का तो पहले से ही Michael Jackson का है.
No, but there are so many copies.
Copies you can do. You can.
Still हम लोग copyright करते हैं किसी भी.
The dance steps I don't think so. I mean that otherwise.
Maybe art form.
Art, but you have not written it, na? If you will just write a note on this, like playing a guitar, you have a note, right? So if you write down that anything you have written, not just physically shown, how will you write it basically, na? So that one.
Things are going on there.
Yeah, I mean this, but it won't be copyright. It won't fall under any of the IPR category. Yes. Yes.
If there is some recipe which is protected by trade secret, and there is some toxic components inside that composition, then how can we prevent that from?
Then we do not know anything. Like if this cola has something which is not good for us, but because they have not disclosed it, we won't be able to do anything. The only thing we can do is stop using that. Yeah. All right. Should we go to the next session? Yes.
So, in the process of filing a patent, I observed that you mentioned 2 milestones. One is still publication, and another is still the research. So, I will actually get what does the publication mean?
Publication is just this, your document, what you have submitted, is simply published on the IPO website. That's it. It's not do not confuse it with the publication the way we publish on the, apna manuscript and all.
So, if it is not granted, anyone can...
Yes, yes. So that's why it is always, in the next session I will be showing you that what precautions you have to take as an inventor so that your patent is being granted.
And one more question.
Yes.
If almost a similar kind of application is filed by 2 parties at same time,
Same date, you mean to say?
or maybe in same period, but then who will be granted that first?
Whosoever has filed first. And if it is being filed on the same day, the data would be seen then, because the examiner doesn't see the documents filed on the same day. So if those applications are there, then he won't be find the prior art for the same. So sometimes strategically as a patent attorney, what we do, that is very similar invention. We know that there are differences, but it may confuse people that they are very similar invention. Then we ask our inventors to file on the same day, so that it won't be a prior art for the other. Because the examiner understands that if it is being filed on the same day, so this might not be, the prior art for this. Should we go to the next session and then we are here for the whole day? Yeah? Everything understandable by so far? Is that everything understandable? Any changes you want me to do? Alright. Now, as I said that I will be talking mostly about patents today and what are the major things. So I have already shared that patenting needs the novelty, patenting needs the inventive step and all, right? So I won't take much time on this. However, alright, so major requirements. So we have spoken much about it, but still again I would go the legal definition of invention. the patentability requirements as I promised that I will be discussing about what is not patentable, then exclusion, landmark, India case laws, and then examination approaching India. So an invention is novel if not anticipated by publication, not publicly known, not publicly used. So this slide has to be seen carefully, right? So that you can understand that what would hinder the novelty of your invention. It's not like that it should only be there in the publication. If it is known anywhere via YouTube, via video, any public use. So suppose I had, there was a doctor from AIMS, I won't take his name, he developed a very good technique for, for diabetes. And he came to us and said that I want to, protect this procedure. I was very happy to see because the procedures were very good and he had complete data of the subjects of the humans he had been working on. I was very happy. I said, yeah, I'll work on this application myself and I'll prepare a patent application. So as my general practice, I just thought that I'll just check whether this kind of procedure. He said, this is very unique, you do not have to do a patentability search. But still, I thought that let me check. So on paper, in publication, there was nothing. But by doing this, I simply saw one video on YouTube and Facebook, or I guess on Insta, that he has made the complete video doing that procedure. And that was in public, right? And then I saw, I matched it with the write-up he gave me and it was exactly the same, right? It was already there in public. So then I called him up, I said, sir, is there anything else which you have not disclosed on your video? He said, no, everything is disclosed and I have made that video to show that how impactful this technique is. But it was not patentable. I sadly had to say that it would not be granted. Even if you want me to write this patent application, I'll write down. I'll do the prosecution also. But I think there are very less chances to get a grant over it. Why? Because it was all there. So anything which is public, either on video, any article, anywhere, that would be considered as a prior art and your application would not be considered as novel. So do not think that it's just the publication. Whenever you are working on this, just find the research papers and patent documents, YouTube, everything. Alright? So that would be. Again, I would say if somebody came and said that I have used aloe vera for my burn. So doesn't it been known from years, from ages, from our Dadi Nani? Everybody knows it, right? So if you go that turmeric I want to patent, you will not get a patent over it because it has been known. Nobody has written anything. I mean, now it has been written because long back few of the Indian scientists went to US and they tried to protect patent haldi on their name. Then the CSIR from here, they just connected to the US patent office and they say that this patent has to be immediately revoked because the turmeric is known in our country from ages and an analgesic, antiseptic, everything. Right? Like my nani, if I have a mood, she will put haldi and sarson tel, right? So this is being known in our country and nobody can protect turmeric. One more problem, what would happen if somebody has a patent on turmeric, would we be able, every kitchen has haldi, right, in our, then it would be a monopoly of that person and he can sell it the price he wants to. Would we be able to use haldi then? So that's the thing. So anything which is present in public, which is known, would not be patentable, right? So this is what novelty is. So if it is publicly known, publicly used or claimed, then you won't be able to get the novelty. What you have to say, do for this, you have to do prior, yes.
So is this any register of the traditional knowledge of TK particular?
Traditional knowledge, yes.
Is there any register?
Yes, the TKDL website is there and you can just check. There are multiple things. Having said that, I would say another thing. So you can't directly do the turmeric. But at the same time, if you have made a composition, you have taken aloe vera, as I was just giving an example for that free conditioning shampoo. So she didn't take one extract directly. She was not trying to protect turmeric or aloe vera or coconut oil. What she did, she took those extracts, in particular percentage ratio and multiple ratios she took, but she showed that what is the best ratio where it is working. So that composition you can protect. That
is it patented or is it trade secret?
it's up to you. If you do not want to disclose that how much amount you have taken for that particular composition.
The compositions are well known, but the ratios are unknown. So for that purpose, it will be like.
How is it possible that composition is known but residue?
Composition, it means the ingredients are known, but
Okay.
ratios are different. So for that purpose, it will be like trade secrets or patent.
Again, I would say it's an inventor's choice. I mean, it's up to you that composition you want to bring it to the public, then you have to go for patent. If you think that nobody can decode it, nobody can reverse engineer it, you can keep it secret till the time you can, but then patent office doesn't give you any certificate for this particular thing that if it is being...
Can I repatent it or patent it?
Repatent is nothing actually. Until unless you bring something new, some technical advancement, it won't be patentable. So if I made one composition, if you suppose you are making one composition with aloe vera, coconut oil, or suppose turmeric, something like this, and then you are trying to just patent it again, it won't be, until unless you bring some technical advancement to it. Right? Okay. So, how will you find out that your invention is novel or not when you are doing it? What you have to do, prior art search you have to do, right? Then identify the closest document. Then compare claim features. So in patent application there is something called claim, where you are claiming that whether your invention is directed towards a process or a product, or what is the process, what a composition is comprising, so all those stuff. So the claims has to be matched with your invention, right? Or all elements disclosed. You have ABC and the other document is disclosing all those elements, then it is not novel. If it is all the documents are not disclosed, it is novel. Now inventive step also I have told you. So how we actually argue for inventive step whenever an invention FERs are coming from BHU IIT, also multiple FERs we are handling at the moment. Even I have been working on one of them. So inventive step problem is there. What we do, the examiner says that these are 3 documents, and based on that your invention doesn't have any inventive step. What we say, we read each of the paper, right? And then we find out that can we combine all these 3 papers and come to my invention? Can anybody do that? So if examiner wants to say that like 1/3 of the portion is been given in the document 1, 1/3 in the document 2, then another part in document 3. So can somebody who is having the same skills, same skills as you are having, can combine those papers and come to your invention? So that is what inventive step means, that okay, anybody can do it then. How your invention is different then? Anybody can read 3-4 papers and combine those papers and come to one single, like number 1, document 1 is saying component A, document B is saying component 2, and document 3 is saying component C. Then you have combined ABC without any technical advancement. The results are almost same. Then you won't be getting the document. However, if you prove that A was working 30% when it was separate, B was working 30% and C was working also like 50%, suppose. If I have combined them, they have that synergistic combination that they have started working to their level best until 80%. That is called the technical advancement. And then even if the components are same, after combining, sorry, if the results are good, then you can get a patent over it. And this is called as a non-obvious, because A, B and C, everybody was knowing that this is what it is performing, this is how it is performing. Now after combining them, it is giving a technical advancement. And then we prove as a patent attorney that okay fine, there is an inventive step. A was not showing this, B was not showing this, right? So this is called the inventive step. Now if I ask you the person skilled in the art, I am using this term many times. Anybody can tell me, person skilled in the art? So person skilled in the art means that a person who is having the same knowledge as you are having, right? If I have done PhD, I have done in molecular biology, and another colleague of mine or a friend of mine who is having the same thinking skill. So that's called the skilled person. Person skilled in that. Thank you so much. Right? So that's called the skilled person, because we cannot expect a 12th standard student to think like that, right? So skilled person means who is having the similar skills as you are having. Can he think of it? So you can't escape saying this, look, my dadi cannot do this. And my son cannot replace this experiment. So that he is not a skilled person, right? So skilled person means that a person who is having the same skills, same educational qualification or experience as you are having.
Whether educational qualification is important?
No, it's not important. So anybody, any inventor who has given any input. So very good question, Dr. Pai. Yes, yes. An inventor, like MNIT, I had been in MNIT yesterday. So there they asked me that I want to add it. Yes, yes sir. And there are many inventors who doesn't have qualification, but they have very important saying in that particular. They can be the inventors. Yes, yes sir. Right. So this is a landmark case where the Supreme Court had that obvious something that a skilled worker could easily think of. Right. So if I have read paper of, suppose like I had a patent on developing a method of transgenic. Right. So if I read 3 papers that okay, someone has used media in this particular range, someone has used another range, I combine those papers. I can easily do that, right? Because I have those skills to understand and I can perform experiments. I can combine this and I can have one invention. So if I am doing it, that want to be inventive. Thank you so much. Alright, mere workshop improvement not patentable. Even if you have combined and it is not showing any, as I said, any technical advancement, it won't be patentable. Must show real technical advancement. So inventive step must not be obvious to a person skilled in the art. There should nothing be that should look like obviously, okay fine, this could have been done by me also when you see that. So that is called as the inventive step. There are other factors also. So as I said that technical advancement is necessary. However, the long felt need, you have done something on the already granted patent which was really important to do but it wasn't there. So long felt need also. Suppose you have made a medicine which was very expensive. It was majorly required by people who are below poverty line, but they cannot afford this. But you have made the similar kind of medicine at a very, very lower rate. That would be patentable because that can reach to the general public, right?
How would you decide this go first?
Then that would be, you have to give the data, and patent office would also again in the examination report would cite those medicines.
Let's say some medicine, similar medicine, let's say medicine X, sale by some company. They may not reveal that what is the manufacturing cost and other things. And they may not express the margin of profit. Let's say second person also making similar type of medicine, although they can in some other way. And yes, if earlier person do not reveal the cost of manufacturing and the cost of margin of the profit, then it's really very difficult.
It is difficult, but generally whatsoever is this commercialized, generally the price is being known, mostly. So if we know the cost, and if they are not selling, then we cannot help, and then we cannot even say anything. But if they are selling, and then we prove that ours is having the same effect, but we are selling, that's the market for generic medicines, right? So if they prove it that we can provide it in a very low cost, and it is very important for the general public, like for Covaxin, vaccines, that was very, very important. So if you prove that, that would also be considered while checking up the application, because the major aim of a patent office anywhere in the country is to provide the best to their citizens. It's ultimately for the citizens, their general citizens. So if you have have the low cost, that is also considered. Also commercial success and how commercial success it is. Suppose you have any invention which you have filed, and after filing you can start selling it. You must be knowing, right? You can start, the day you have filed, you can start selling. So it has a commercial success, so that means it must be having something, right? So that is also sometimes being considered by the examiner, that okay, it's commercially successful. So those data also is being given sometimes as an affidavit by us to the patent office that this is commercially successful and there must be something. So that's an invisible data coming from the public itself, right? So this is how we argue sometimes if we do not have anything else. Then unexpected technical effect, I have already said. Synergistic also, I have already mentioned that if you have combined, it should give really some synergistic effects. Now, non-patentability under section 3 and 4. This is a very crucial thing. Even if your invention is novel, inventive, industrial application is there, but it falls in any of these categories, it won't be patentable and it would outright be rejected. Now, what are those inventions? Any frivolous invention. Frivolous means any, suppose you are coming with a device and saying that this is 100% input and 100% output. Is it possible? It's frivolous, right? It is not possible. So this won't be, granted. Then comes a contrary to the public order or suppose somebody comes up with a method of stealing the stuff or theft. Should it be patentable? That wow, what an idea, Ajo, I'll give you. So anything which is against the morality would not be patentable, provided it is, even if it is novel, inventive, industrial applicability, whatever, it won't be patentable. Then comes mere discovery of a scientific principle. Suppose you have found out a bacteria, you have found out a lake somewhere. You can't come up and say that I want to patent this particular thing on my name because you have simply discovered it, right? You have not made this. So any invention which doesn't have any human intervention, this, yes?
For the Pseudomonas stupida, that bacteria takes the policy like Anandamun Bhakti. Like he get patent for that bacteria.
You must have genetically modified it. You can protect. Definitely you can protect. But it should have, simply isolate and come, won't work. It has to be some human intervention.
Like not discovery, it must be invention.
It would be invention if you have genetically modified it. And sometimes people are simply discovering very, very hard, isolating very hard, bacteria and microorganisms. In that case, you can get a patent over the method of isolating that bacteria, right? Not the bacteria, because the bacteria you have not done anything. You are simply saying that this is a thermobacteria, this is a bacteria which does this, but it is doing by itself. You have not done anything. And if you have genetically modified, you have knocked out some gene, you have done something, you have anything you have done, and you have just interfered in his system, then you can get a patent on bacteria also. So what you have to do, you have to first submit. There are few centers. We have signed a Budapest Treaty where if you are working on microorganisms, then you have to submit those microorganisms in those treaties, under those treaties, and you will get an accession number. The way we get the NCBI, the sequences and all, we get the accession number. You will get an accession number and then you can write down that accession number in your this application. And then you can get a grant over that, on that. But if there is no human intervention, then you won't be able to get any bacteria, anything which is natural, you won't be able to get a patent. Mere discovery of a new form or any method, if you have made paracetamol, the same composition you are using for fever, and then somebody comes up and says that I have used this same composition and it helps me in pain also. So this is not patentable under section 3D. They say that it's a new use of any method or a new use of any composition. So use would not be patentable because you are not giving any new composition. You have just discovered that it can be used there also, right? Mere admixture, as I said, that you have simply combined A plus B plus C. A is working in its own mode, B is working in its own mode. They are not giving the synergistic effect. And there is no point why have you combined them. They are working in their own domain. Then it would not be patentable. So whenever you are giving synergistic data. How would you generate? Then give us a data of A, what is A doing separately, B and C, and then combine them, and then give us a data with the same percentage ratio that it was doing separately, how it is working, and then when we are combining, how is it giving you the synergistic effect, right? Then comes the arrangement or rearrangement of any device. This is mostly in terms of devices. So if you have a device, you are claiming a device and you have simply said, I had a stool and I just fixed this handle to at this place and that handle to this place. This is not invention. Until unless you show some technical advancement to that, you will not get a patent on it, even if you say that it's novel. Then comes the method of agriculture and horticulture. So if you say I have sown a seed 3 feet away from each other, so this is a kind of method of agriculture and you won't be able to protect it. And there is one major reason. India is an agricultural country, right? And if you put such kind of monopoly to somebody, if I go and say that I have a grant over this, that this is how you should breed a plant, right? How would the farmers, would they come and take the permission from us that you have the monopoly? And then I would ask money from them that, okay, I'm giving you this patent and then you can just give me the money. So this is not patentable in view of the public health, I would say. So any method which is related to agriculture, horticulture would not be patentable. Having said that, I would definitely say that if you are developing anything, like I developed a method of developing transgenic and it got a patent because our team in my lab, we did actually multiple human interventions and we were simply giving a method of transgenic plants which is not being used by the farmers. It's not the method of agriculture, right? It was simply a method. Then method of treatment is a big no. If the moment you write down a method of treatment, it won't be patentable, right? So anything, method of diagnosing. So this word has to be avoided anytime. So if you are, thinking of making any method of treatment, just put them in the form of composition. There must be some composition, right? Which was being used to treat that particular thing. So method of treatment is a big no. Method of diagnosing something is a big no. And then again there is a reason. If a method of treating something has got a patent by somebody, he can have the monopoly. And the poor people who are not able to afford that particular person's monopoly would not be able to get that treatment, right? So this method of treatment, so this is allowed in US. The USPTO, they can allow the method, this claim method of treatment, but in India and Europe, method of treatment is not allowed. Then plants and animals in whole or any part. So the plants and animals. So I had a very interesting story when I was in my patent agent exam. So for a patent attorney, first after doing my PhD, I appeared for a patent agent exam. A patent office conducts that and many of you can also do that. You can help in that also. So I went for the interview. So I clarified the exams and all. I went for the interview. So the panelists, they were sitting there and they were tired actually after taking so many interviews, They were like 200-300 people. And then he asked me, did you see any buffalo while coming? I was like, I'm here from the morning, and then he's asking me, have you seen any buffalo on your way? I said, no sir, I didn't see. But okay, if you have a buffalo who is giving 20-30 liters of milk every day, can you have a patent on the buffalo? So his means that he wanted to know that can an animal be protected? So is it possible? If somebody comes and say, I have a patent over Shweta, is it possible? I have a patent on her hand, that this hand will work for me only. Is it possible? Should it be like this? No. So you cannot patent any animal, any plant, any part of plant. You cannot come and say that the seed is being patented by you. There are other ways to protect plants. If you have developed any transgenic seeds or transgenic plant, you can go to bonsai technique. So sir, that would again come under the patent. You can just say that a method of developing, bonsai plant or something. But for plant like seed or transgenic plant, you will go for the plant protection by variety protection, right? But not the patent. So then he said, okay, you have not seen buffalo. Buffalo too is giving milk a lot. Then that invention is just gone. So then I said that we can protect that method of enhancing the milk delivery from the buffalo. It's not waste. We can definitely, but we just have to think that what is patentable in India. And then accordingly, we have to prepare that what we can go for the claim. So any part of human, animal, any part, plant part would not be protected. However, the transgenic plant seeds, they can be protected under plant variety protection. So there is another act, right? So you can just protect those things. Then any mathematical business or method computer. So if you have developed any mathematical calculation, mental games, it won't be patentable. Literally, dramatic, musical, this won't be patentable. This you can go for? Exactly. Then a method of performing mental act, like you have a mastery in performing chess. So you can't go and say that I want a patent on this, right? Then presentation of information. I am presenting this, but I have also learned it from somewhere, right? I can't say, I can get a copyright on this, on my presentation, but I can't patent it, right? Then topography of integrated circuits, you cannot have patent on this. Any traditional knowledge, as I said, you cannot go and say that turmeric, I need a protection on that. Then section 4 is there, which is related to the atomic energy, and the patent office, they are very, very strict about it. So we have multiple DRDO projects. They develop such kind of inventions. But then patent office specifically checks those inventions because it is related to the atomic energy. And if the patent office thinks that it should not be patentable, they can reject them under section 4 of Indian Patent Act. Right? So clear till this time? Everything clear? Okay. Now, as I said, the patentability of microorganisms, this has to be protected and there should be a human intervention. So, microbiological inventions include new products, process, uses and composition. These inventions cover method for isolating and acquiring new organism. As I said, that the organism exactly cannot be patented, but how you have acquired it, how you have isolated, that method can be patentable. Right? The patent for new microbes is based on the characteristics of the microbes available in the prior art. So if you have any microbes, you have an human intervention, then you can file it. Known microbes are restricted. The same thing, the novelty should be there. If you again come up with the same bacteria, even if human intervention which is performing the same, it won't be patentable, right? Then deposition of biological material. As I said, that Budapest Treaty is being signed. And we have to submit, before filing any application, we have to submit the culture at this, MTCC Chandigarh, or there is one in Pune. You have to submit, you have to send the culture there, you have to submit, and they will give you an accession number. So that accession number has to be mentioned in the patent application, okay? So under section 10(4) and rule 13(8) of the Patent Act, an applicant must deposit the biological material mentioned in the specification. So before the filing of the patent, right? Okay? And sometimes it takes time. So what we suggest that you can file a provisional application and simultaneously you can apply to these deposition center to wait for the accession numbers. The material must be deposited with an international depository. So these are international depository in India, in Chandigarh and in Pune. So you can deposit there. So these are the few things. The time period no later than the filing date of the patent application. That means before the filing of the patent, right? How will you protect the software in bioinformatics? Because it's like a gray area, I would say. That softwares are not patented. How would we do that? So for being granted as a patent, it's necessary that the program is not merely an algorithm, but is a technical invention, right? As per section 3K, the computer program cannot be patented per se. For a computer software to be eligible for patent grant, it must not be business method, mathematical or a computer program. So these all things are not patentable in India. However, a software can be protected if it is attached to an invention that is component of such. So any hardware if you have connected. So there are some dongles, there are something which is required to run that software. So if you attach that hardware, then it would be patentable. Or if you are coding, like, so what method. That way you can get a protection on that, but it has to be a method sort of thing. So the method can be patented. Right? So the inventors who are into this field, the informatics and trademarks, so what you can do, you can trademark those particular, the coding things and all, and you can have a copyright on this. Okay, so softwares can be copyrighted very well. Okay. Then another thing is industrial applicability. As I said that if there is no industrial applicability, as you asked the question, that I have combined the music with stapler. But what is the industrial applicability? How is it helping people? If there is no help, then it won't be granted. Sufficiency of disclosure. This is very, very important, right? And I will just mention here that sometimes few of the applications from the very renowned institute, they do not share the whole data, right? And they think that no, I'll just hide this. But later on the prosecution time, it is very, very difficult to get away from those objections because we do not have data. So you should sufficiently describe that how an invention is performed, that the next person who is having a skilled artisan can just go through and perform that invention, right? So the data should be sufficient, or under section 10(4), objection would come of insufficiency, right? So it has to be there. So complete specification must fully describe the invention. However, this is not true for the provisional application. If you're filing a provisional application, part of data is fine. You just are giving the consent, right? So you can file a provisional application. Provisional application doesn't get published. So nothing to worry that whatsoever you have written would be in public. So that if you are not filing a complete application within 12 months, that would automatically be abandoned. So most of the inventors, they are taking this strategy also to just simply save the priority date. That I'll file a provisional, and if I am able to finish my experimentation within 12 months, it's fine. If I am not able to, I'll just let it be abandoned and I'll file a new application. Because that is not going to be published, the provisional application, right? You also have to, so another thing which I write in most of my application when I'm asking from inventors, that if you have worked, suppose component A is being used 14%, component B is 7%. So as an inventor, I understand they simply write 14%, 7%, right? But that is restricting our invention. Somebody later on comes up with 20% rather than 14% and getting a little bit of technical advancement, that invention would be granted to him also, because our invention as a prior art is not able to, prove that it can work on 20% also. So what I always, if something is being written like this, I always suggest to give a range, the broadest possible range, right? And then give one example on 14%, so that we can show, okay, 10 to 20% we have mentioned, it is working on 14. So it may not come that way on, as it is coming on 14, but 10 to 12%, that ratio or that range has to be given. Never just quote 1%, one amount, never ever do that. Okay, always give a range. Temperature you are using, sometimes it is being written room temperature. So you should write like 24 to 27 or 23 to 28, something like this, If it is specific for east zone, it's like 28. So you can write it. But if you can provide a range, always provide a range of all the parameters, conditions, components, everything, so that you can broaden your invention, right? So that the next person who is filing, who has just seen your invention and then he is performing on some, he has just tweaked it a little bit and he has also got the grant. So later on, if you are going to commercialize it, you have a very strong competition, right? Because he has also got the patent. Alright, then insufficiency, ground for revocation. If your invention is not sufficiently given, then it could be, not granted. Then prior art, I'll just be, am I running out of time? Okay, so I'll just quickly tell you that how can you find the patent document as I promised you, and this is very, very easy, trust me. How does patentability search report help? I have already told you that the patentability search report provides an accurate idea to an inventor about the novelty and non-obviousness, because these are the major things on which your grant of the application based upon, right? So this has to be there rather than just blankly start experimentation. So if you are doing a prior art search, it would help you that how to do, what are the prior arts and what are the loopholes basically, right? The inventor can accordingly rework his invention and modify the patent invention. So even if you have an invention, you have done the prior art search, then you will find out, okay, fine, how my invention is different, right? And then you can modify it. The inventor may avoid duplication of research, reduce R&D investment significantly, and develop new technical solutions, right? Even if you find that the closest document that what you have done is being already there, what you can do, you can save money on redoing those experiments. Then you can find out that what else can I do? Where are the loopholes? Where are the gaps where I can fill it, right? Inventors may evaluate a specific technology and plan new products, even if it's like roses. But you know that it's not like that after rejected by the patent office, you are getting to know that your invention. So the patent office should not tell you that your invention is not novel. You should know beforehand, right? And the patent office would cite the similar document. You have the arguments ready with you, correct? It helps you find legal status of the patent applications, keep abreast of new technological trends. So you have multiple things when you do a prior art search. However, mostly even we do a patentability search with the paid databases and we give you a report doing this. But that, of course, charge a bit. So what you can do, I am going to give you a basic brief how you can do it by yourself. I'll also tell you how you can make a string, what websites you can use, and how you can do it. So select the patent search databases. So I, as an individual inventors or as an institute, I would not suggest you to buy those 12 lakh paid databases, right? So you have free databases, multiple free databases. So this is Google Patents. This is one of the most used, just like a Google Scholar, and you will find it very, very friendly. Okay? So you will not find it, very difficult to go through it. Google Patents is there, European Patent Database, the Lens, Free Patent Lens. So these are few free databases, where you can just go, type this, keywords, make a string, and you can find the patent documents of your invention. There are few paid databases, Questel, Government, Patsio. Patsio is something which is being used by the patent office, and we also use this particular databases so that we can get those documents beforehand what the patent office is going to cite, basically. Now quickly, again I would say, as I have told you, that prior art is any information which is public domain, video recordings, newspaper, magazine articles, speeches, journal papers, patents, etc. These are all. आपने कुछ invention किया and then you went to a conference, you have just told everything about your invention and somebody has recorded it, somebody has written it. That would be a prior art, considered as a prior art, okay? If it is in public. If it's public anywhere in the world, it is a prior art, okay? Now, an invention can be patented only if it fulfills the criteria, right? So, these are, we have discussed that you have to do the patentability search to find out novelty and all. Now, the step one, this is how a Google Patents looks like. When you go to your browser, this is how it would look like, okay? Google Patents would open. Now, what you have to do, identify the keywords. That's what we do in our manuscript also, right? We find out the keywords, okay? You have to find out the keywords. Now, suppose we are trying to crystallize 2 or 3 main components. So, this is a car windshield, okay? And this is a wiper. And here we have to identify the keywords. So you know that what are the keywords of your inventions. So important keywords here are wiper, fluid injector, car, windshield, right? These are the important keywords here. What will you do here? Set up the search terms. Find out the synonym and similar concept for each of the keywords, right? It's not like that you have just put one word and that's over. Go from general to specific. Have all the synonyms. How would you do that? The wiper, ho sakta hai some of the inventors might have mentioned blade at the place of wiper, right? Might have placed arm at the place of wiper. So that patent document should not be left out. So find out the synonyms. Then fluid injector can also be named as fluid spray, water spray, cleaning solution, correct? So you have to think of that also. Sorry. Then car can be called as vehicle, automobile, four-wheeler, anything. So you have to do these synonyms. Windshield it can be windscreen, glass, anything. So first you have identified the keywords. The second step is to find out the synonym of these keywords, right? Step 4 is creating a search string. Use the truncation, parenthesis and Boolean operators. What are these? Operators and Boolean operators like AND. So suppose, if you see, if I want to find a car or automobile, these are synonyms. So in all the synonyms, what would be the operator? Or. Because we are adding synonyms. We will close them with the parenthesis, then we will start with the new word, then we will put AND. Because we are starting with the new word. Then again we will start a parenthesis, again we will use the new word or its synonym. So this is how you create a search string. So apart from using these Boolean operators, we can also use truncation operators and multiple things. You do not have to do it. You can simply put the synonyms using OR and then a new word with AND. Okay? And if you see the example, car or vehicle or automobile or four-wheeler, bracket close. And windshield, windscreen or glass, bracket close. So this is the whole key string you have made. You have made it. Now search it, right? Modify search terms to suit each search engine. So if you are using Google patterns, this search engine with and or is sufficient for you. Okay? You just do that. When obtaining large number of results, check for obvious exclusion, right? What you have to check on the patent document majorly, read the abstract because patent documents are like very, very long documents. What you cannot sometimes read those many documents. What you have to check, you just have to read the abstract and then the claims. So claims are the heart of any application. If you read the claims and you can compare that what they are saying and what we have. Okay? And then doing this, you can just narrow down the number of those prior art documents. As soon as you get down to below about 200 results, it becomes manageable, to quickly see that what are the claims. Make notes of the relevant ones. So whatever documents seems relevant to you, you can simply make note of that and then you can compare them in details. The number of results you obtain is a big indication, that how your invention is close to some of the other inventions. And sometimes it is not even, very close to any of the invention if you are lucky one. Step 6 is to summarize, discuss and rate. So once your search is complete, examine the relevant arts in detail, right? Then discuss the reason why your invention is patentable. So if why your invention is novel, right? Why, how do you find this inventive? Have you read 2-3 papers and then can any skilled person come to this particular invention? If your answer is yes, then go for another prior art. If your answer is no, your invention is inventive. It can also help you to identify any further improvements. Even if you find out the closed documents, you do not have to be disheartened. You can simply modify, right? At the max, you can just have to narrow down few of your inventions, right? But it's not, doesn't mean that you will not be working on that particular aspect anymore. Other ways are also for searching from classification ID. It's not that relevant for you. And then this is the other related claims and how does it look like when you are looking for. So for computers or for these things, a system for predicting the properties. So this is, you can find out in your claims that what exactly, these are the structure of claim, that how the claim look like. And then it has a body that it is explaining that what an inventor has done. And if it is not exactly matching to your invention, then your invention is novel and inventive. Right? So these are few things, few references which you can go through. And before ending this up, I would also suggest definitely go for Google Patents. It would be very helpful for you because you are very familiar with the Google Scholar. So you will not find anything new. The same thing. So to start with, you can go for the Google Patents and you can find out that whether whatsoever you are thinking is novel or not. And if you find out 3-4 documents, just find out whether it is inventive or not. Any questions? Thank you. Thank you. Somebody was asking that time a question from here. Any questions? Everybody is hungry? So I'm right here. We'll have an interactive session also at the end of the day today, right? And you are free to ask any question related to anything. All right. So you can just ask me anything, whatever you want. How I jumped into this field, how you can be a patent agent, how helpful it would be for you. You can write down your own patents, right? So just I'm right here. You can come back after lunch and we can talk. Thank you. Thanks for your patience. Thank you.
Thank you so much, ma'am, for such an informative session. Now I would like you to take a break for a lunch, and you are requested to come by 2:45 sharply. And the lunch will be at GPAC Dining Hall, Guest House. Hope everyone knows it. In front of Gandhi Smriti Hostel, near Limdi Corner.
Lunch has been arranged for everyone in